Hello. I'm testing my volume. Can anybody hear me? Hello. Oh, thank you. All right. I know I could be heard through the wall. I was checking on the electronic side here.
I can hear you, Supervisor.
Oh, fantastic. Thanks, Val.
Hello, can you hear me? Okay,
I hear you.
good. Thank you.
Good to see you.
We can hear you too, Bill. All right. Good morning.
How are you? How are you doing?
Doing well. I was once again accosted on the street, and Bill over at this. Hi, Bill. How you doing?
Hello. Good
Hi,
morning.
Judy. Hear you. Great.
Okay.
I was so busy reading, I didn't look at the time, and then all of a sudden I was like, oh my God. So,
Good afternoon, everyone.
hello, Lena. Good to hear your voice. I think we're missing our vice chair is all. Has anybody heard from him? Lindsay, have you heard at all from Geronimo?
Lindsay, would you mind promoting Jay Crystalman and Mark Stento to panelists?
Andy, this is Val. You wanted, I think actually you need to probably did that. Sorry.
Jay and Mark and Essler as well.
Okay, thank you.
Good morning, everyone.
Good morning, Jay.
Morning, Jay. That was
Morning.
a great article in the paper.
It was, yeah. Thanks for that.
Yeah. That was a cool picture of Mark.
It was.
They
That
gave
was
him
back
credit
when
for
he was-
working for the city of Flagstaff. They didn't note that we had stolen him from the city of Flagstaff, and he's now a proud Coconino County employee.
That's a fact. Yes, he was joint funded then.
Yeah, it was a nice article, guys. And I heard from Matt, it was a really great presentation, and everybody did a great job. So thank you all for being there on behalf of Coconino County, and Matt for once again kind of raising the dark sky philosophy here. So really appreciate it.
And Vice Chair is with us as well.
Oh, good. Then we've got
Good morning,
all
everyone.
of us. I gotta love that. So And it looks like to me, it's exactly 11 o'clock. So let's go ahead and get ourselves started on this. Andy, do we have all the staff we need for this? I do see our County Attorney Bill Ring is with us.
We do. Thank you very much. I communicated with Steve today. He will not be joining us, but we are fully staffed. And we have our presenters here, and thank you, County Attorney Ring, for being here this morning.
All right. So let's go ahead then and get going. Today is Tuesday, June 13th, 2023. This is our special session. We have both an executive session and a regular session scheduled here for this morning. And our first order of business is to call ourselves to order. Make sure we have our board members with us. And my name is Patrice Horstman. I'm the chair of the board, and I'm the supervisor for District 1. District 2.
Good morning, everyone. My name is Jeronimo Vasquez. I'm supervisor for District 2 and current vice chair.
And District 3.
Oh, there you go. Trying to unmute. Matt Ryan for District 3. Happy to be here. Good morning, everybody.
Good morning, Matt. District 4.
Good morning, everyone. Judy B. Gay, District 4 Supervisor. Welcome.
And District 5.
Yes, good morning. Here we are, and welcome everyone to our meeting. Thank you.
So the gang's all here. We do have as our first order of business is a presentation, discussion, and possible action regarding the update to draft ordinance 2023-04. That's our short-term rental ordinance. And we have our county attorney with us, who has been providing wonderful advice and information to us on our ordinance. And we can go into executive session to allow an opportunity for our county attorney and his staff to basically go over a proposal to the board on our draft ordinance. To do so, however, I need a motion and a vote to go into executive session for advice from legal counsel and to provide information on our short-term rental ordinance. Do I have such a motion?
Madam Chair, this is Andy. If you don't mind, I think Jay has about a 10 or 12 slide presentation we could go over prior to any executive session that we may choose to go into.
Well, and I did look at his presentation. I have no problem with that. It looks like suspiciously what we've gone through before, although I think it's really excellent for us to go through this again, to remind the board of our short-term rental ordinance and the limitations we have pursuant to statute. So if Jay, you think it works better for you to make the overall presentation as a reminder and an update for the board before we go into executive session, then I will, and see no objection from the supervisors. Let's go ahead, Jay, and let you go through this. As I said, it looks very familiar to what we have looked at before. And as you know, we have had a hearing and heard from members of the public on our short-term rental ordinance. And after advice and information from the board, we turned it over to legal for review and for further drafting, which has been done. And I know we're going to go through that again here in just a minute with our county attorney. So sure, Jay, it's always good to see you. Take it away.
Thank you, Madam Chair. While Jay's pulling this up, it is similar to what we've seen before, but some things have happened since we've last heard this or seen this. Well, one is the city of Flagstaff is also going through a process, and Jay and staff have been tracking that very closely. And I believe the last slide talks about a path going forward and in a hearing process going forward in a timeline that we're looking at. So Jay, take it away. Thank you.
All right. There's changes. I love change.
Madam Chair?
That's great.
Madam Chair.
I'm sorry,
Madam
Judy.
Chair.
Yes, Supervisor Gay.
On these amendments, anything that comes before us, maybe if I know that we go through several amendments and I just wanted to say that maybe in the presentations, just let us know which parts of that is a new version or whatever. I appreciate it that, from the amendments to the amendments.
And
Strike,
Judy,
underline it or something. Thank you.
yeah, Judy, I think that it was a complete rewrite, quite frankly, on format as well as some of it. But I think we'll be going through that when we talk with legal here in just a minute. It looks like we're just going to get the overview. So thank you for that, Judy. So anybody else have any comments before we turn it over to Jay? Jay, it's yours.
Madam Chair and Andy, thank you both very much, and Supervisor Brigade for the introduction. You're 100% correct. So I do have two new slides that highlight the substantive changes. Before I get started, I would like to thank County Attorney Bill Ring for the finishing touches and the fine tuning and the reorganization of our proposed ordinance. Substantively, there's not a tremendous amount different, but I will be going over that in this presentation. So thank you. And you're right, Madam Chair, it does look suspiciously familiar with some of the other presentations. So just as an overview and that, so the board, a recap of what we've already gone over, I think it's a good refresher. Back in July, the state did allow local jurisdictions to require either a permit or a license. The county's calling it a permit, the city's calling it a license, very similar. We have permitting, they have a license department. So it does allow for the collection of up to $250, and that is annually for a permit fee for the continued registration of the short-term rental. Requires a minimum of $500,000 liability insurance for that rental. None of these items have changed. Our search on most of the reputable sites for short-term rentals are $1 to $2 million. So that's already going to be met for most circumstances. It does require the operator of a short-term rental to notify the neighbors that there's a short-term rental next to them, and that is directly adjacent to and diagonal. Madam Chair, I heard somebody maybe try to ask a question.
Didn't hear that. Anybody have a question? Look, please continue.
Okay, thank you. The STR operator is also required to provide an emergency point of contact to be notified and respond to either emergencies or complaints. Again, this is still part of the original legislation. It does require the operator of the short-term rental to obtain a transaction privilege tax number. That is also unchanged. It allows for an increasing style of financial penalties based on occurrences of violation, verified violations, and the time it takes to resolve those violations. It does prevent the short-term rental for allowing venues such as special events. We see some that host weddings, for example. We see that with a handful of short-term rentals right now. So this will give us a tool to address those even more efficiently. Again, these are still part of the original provisions. Nothing's changed here. There's a thorough outline of the enforcement and citation process. Again, I'd like to defer to County Attorney Bill Ring and thank him for making that portion much clearer for us. So that did change a little bit as far as the thoroughness of that. And then allows for a suspension or revocation of a short-term rental permit for up to 12 months, but that process still does have to go through a hearing officer. Any questions on those provisions that, again, have not changed?
I don't see any. Please proceed.
Thank you, Madam Chair. So those verified violations that I just mentioned, those have remained the same as they were with our previous iteration. So a felony offense committed at an STR, a serious physical injury or wrongful death that happened at a short-term rental with the owner's intentional reckless conduct, owner of a short-term rental housing registered sex offenders, having adult-oriented businesses operate there, or operating as a sober living home. These are all prohibited and are verified violations. And of course, the owner hosting an event that would otherwise require a temporary use permit. So commercial activity, and I showed a picture of a wedding here on the slide, because again, that is the number one thing that we see that is in violation. at short-term rental locations. So again, this will give us another tool to address those violations more efficiently. So the enforcement process and the revocation of suspensions, as I had mentioned, they do have to go through the hearing officer process. We do have an appointed hearing officer with community development. The cost is $400 an hour for that hearing officer. So there is some cost associated there. And I wanted to mention that because staff is proposing, and I believe tentatively has been approved, the one full-time administrative assistant. We currently have a part-time administrative assistant, proposing that to go to full-time, as well as an additional code enforcement officer for specifically for short-term rental administration. So we're looking to the permit fee to cover the costs of the hearing officer if necessary, and where applicable, and of course for the administration of issuing the permits for short-term rentals. So now we get into the substantive change with this proposed iteration of our short-term rental ordinance. So through legal review, it was determined that we can use verified violations as a failure to obtain your permit or register. Those things that I mentioned previously, such as you have to notify your neighbors, for example, you have to obtain a transaction privilege tax number. You have to apply for the permit and go through the process to obtain it. So we now have a much more effective tool to address short-term rental operators who violate or otherwise fail to register through the permit process. And the way that it's been written, and County Attorney Ring can correct me if I'm wrong, or in exec session, but the way that we currently have it is that process can now be filed directly with Superior Court. So we don't have to go through the hearing officer process. For those of you that are familiar with that, it's a cumbersome and timely process. It can be if the violator wants to fail to work with us. And it also gives the department the opportunity to issue fines directly from the department. So it's a much more effective tool. The way that it is currently written is a much more expeditious avenue. And of course, our goal is compliance. So that is the substantive change with this particular rendition of the ordinance. And I'm happy to take any questions before I proceed.
And I know we are going to be going through a lot of these substantive changes with the county attorney here in executive session, and you're just providing us the brief overview right now. So,
Madam Chair, that's correct.
yeah. All right, thanks.
Yep. And as you mentioned earlier, it has been completely reorganized. I wouldn't consider that a substantive change. It just flows much better, but the elements of statute are still present in the document. It's just better laid out. The next steps. So I do believe the board had mentioned at a previous work session that they'd like to have the hearing on August 8th. If I'm overstepping, I apologize. Staff is requesting a 120-day grace period from that hearing until when the ordinance goes in effect. The City of Flagstaff is proposing the same thing. The reason for that is twofold. One is to get the educational component out to the community that we have this ordinance now. We suspect there will be a lot of short-term rental operators who maybe they operate an accessory dwelling unit out of the home that they live in, or maybe they operate a short-term rental out of above a garage, for example, and they live on the property. We suspect that a lot of folks in those circumstances won't know that this ordinance exists. So we wanted to give them time to obtain their permit. The second is that statute, and then reflective in our ordinance, requires the department to issue or deny the permit within 7 days. So our fear is that if it goes into effect immediately, there could be, we'll just say 1,000 applications in a couple 3-4 week period, and we just don't have the staff capacity to issue or deny a permit within 7 days in that circumstance. And if that 120-day grace period is established, the ordinance would then go into effect November 14th. And with that, I'm happy to entertain any questions or listen to discussion.
All right, thank you for the reminder on what the limits of the law are with regards to our abilities on short-term rental ordinances and to really point out some of the substantive changes, Jay. And we may have some questions when we come back out too, if we do go into executive session. But for now, any questions, members of the board? Or if not, I would now at this time entertain a motion for us to go into executive session, to go through, get some legal advice and go through some of these substantive changes. Do I have such a motion to go into executive session?
So moved.
We have a motion by Vice Chair and a second by Supervisor Ryan to go into executive session. All those in favor going into executive session, please signify by saying aye.
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 Supervisor Begay, are you voting?
Aye.
All right, thank you so much. We've got unanimous. Let's go into executive session. Now, members of the board, remember, you need to leave our open public meeting. And I believe that Lindsay has sent us the executive session link. So let's leave now and go into executive session.
It looks like we have Lena, Judy, Geronimo, and we have Matt. There he is, Matt.
Yeah.
Right, Matt, there you go. All right.
Yeah, we were good.
Okay. Somebody has not left the Zoom, so currently audio can be heard on the Zoom.
Looks like we're coming back.
I'll be back in just 1 minute. Okay.
Right. See, we have Judy back with us. We're missing Matt and Lena, but I'm sure they'll be with us momentarily. Matt's with us, I should say. They're Geronimo. And
I'm here, Madam Chair. This is
there's
Lena.
Lena. Thank you, Lena. And I see Geronimo and Judy, and Matt will be back with us in just a second. And I see that Bill Ring is back with us. I do not see Heather. Bill, do we need Heather with us? Oh, there she is. Sorry, Heather.
That's all right.
Okay, and I see Jay. So good. Well, members of the board, we are out of executive session. We've received legal advice and a review of a proposal for some changes on our short-term rental ordinance. And with that, I think it's appropriate at this time to turn this over to our county attorney for some overall comments, and then to take us through this substantially revised draft on our short-term rental ordinance. So, Bill.
Thank you, Madam Chair and members of the Board of Supervisors. And I'd also start with particular thanks to Jay Crystalman and Mark Stento in the Department of Community Development for their assistance with the development of this substitute draft of an ordinance for the regulation of short-term rental. Just so you know, the community development staff put together a draft that our department relied on to create this new variation of the ordinance. And so thanks first to them for putting together the scaffolding that we reworked to give you the draft that you see before you today. A couple of preliminary items with regard to this version of the ordinance. It's drafted in plain language so that when the public reads it, particularly those who would host short-term rental, that they'll be able to go through it and understand what it is they need to do to be in compliance with the law. The second thing it does for those who would be guests of the hosts, it gives them some confidence to know that if a host has gone through the regulatory process, that as a guest, your host is a legitimate vendor in short-term rental and has attested to the fact that the unit that they're going to be using is registered, is compliant with the TPT, that's the transaction privilege taxes and other regulations from the state, and that their host in effect is a host in good standing with the county of Coconino. So it's the ordinance serves that purpose. And the third thing I would tell you before we delve into the specifics of the ordinance itself is to talk about your jurisdiction. So this ordinance, if it's adopted after a public hearing, is effective in the unincorporated areas of Coconino County. What that means is that if you're in a municipality, the municipality has its own authority to regulate short-term rental, and we are not attempting to regulate inside municipalities in Coconino County. Our jurisdiction extends in the unincorporated areas of Coconino County, areas which each of you have in your separate districts. And so for anyone in the public or those who are listening, who are observant of our activities in the area of short-term rental, this applies only to the unincorporated areas of Coconino County. And those who would be listening, if they have an interest and they reside or own units in a municipality, they should check with that city council and that city's attorney. So with that introduction, I'm happy to lead you, Madam Chair, through the major sections of the ordinance.
Yeah, thank you. And could you underscore about HOAs as well, just as a precursor?
Well, it's a very good question. Thank you. Homeowner associations are private organizations. They have an authority, it's a limited authority to regulate activities and behaviors in their neighborhoods. The county will adopt, if it adopts an ordinance, it's not intended to substitute for what HOAs independently can do, but an HOA may or may not decide of its own accord whether it wants to regulate in the space of short-term rentals. So HOAs can adopt their own, take a look at and adopt their own regulations that can be more strict than the county might adopt for the same area. But the county's adoption of regulation of short-term rental, if you choose to do so, is not a substitute for HOA regulation. The two entities are two separate things. And so an HOA could refer to the county's ordinance and say that that's the extent of our regulation. They could regulate further. But regardless, the county, should the county adopt a short-term regulation, it's despite the fact that an HOA may or may not do the same thing. So these are really two separate things is what I'm saying. They're not to be confused with each other, and an HOA can regulate in this space also. Though it's the public should not confuse an HOA regulation with a county regulation.
Thank you. And with that, it'd be great to kind of take us through the ordinance.
Thank you, Madam Chair and Supervisors. I've got to put my glasses on to do this, and I'll be looking at the ordinance on my desk here in the County Attorney's Office. I may read verbatim, but what I really want to do is summarize the main features. So if you take a look on page 1, this is an 11-page ordinance in 14-point type. So just for those of you who are listening, I don't intend to read this like I'm reading, the ingredients on a label of some product that you bought. I just want to hit the highlights. Section 1.1a is the purpose, and this is worth reading verbatim. The purpose of this ordinance is to protect public health, safety, and welfare of owners and users of vacation and short-term rental properties in the unincorporated area of the county, and to protect the residential character of neighborhoods and surroundings that are adjacent to vacation and short-term rental use. Okay. So that's a clear and concise statement of the purpose. Regulate owners and renters and protect neighborhoods. It is unlawful to rent or to offer to rent a vacation or short-term rental property without complying with the provisions of the ordinance. And so from our drafting perspective, Madam Chair, it was very clear to put out at the front of this ordinance in simple terms so the public can understand that the intent of this ordinance is to regulate the ownership and rental of these short-term rentals for the purpose of protecting the residential neighborhood, the residential character of the neighborhoods where they're located. The next section is about authority and limitations. We identify where your authority in statute comes from and the applicability of the ordinance to short-term rental that exists on and after the date of adoption. But of considerable note is that all the applicable provisions of other regulations that the county has adopted, such as the zoning ordinance and the building codes and public health and safety and sanitation codes and environmental codes and regulations and traffic safety and traffic control, shall apply to the use of these short-term rental properties. So in other words, an owner or a renter of short-term vacation rental stock must know and is put on notice that all the other regulations that apply in the fields of public health and public safety also apply to short-term rental use. So the next section is about limitations and the emphasis upon residential purposes. So importantly, the use of property for a vacation or short-term rental activity must conform in all respects to the purposes of the underlying zone where the property is located. Vacation and short-term rental uses upon land zoned for single-family dwelling purposes, delineated in our land map for Coconino County, shall conform to the definition of family as that term is defined in our zoning ordinance. And the reason why this exists in the draft that we created is that when our neighborhoods, our citizens think of what a single family residential unit is, a house, multifamily apartments, what people expect in the neighborhoods is that this unit will perform like a residential unit, just like we would have in our neighborhoods and behavior that we would see from our neighbors. So short-term rentals are expected to conform to the behaviors of the single-family residential zone. And I think that's really the purpose why that language exists, Madam Chair, is to protect the character of our neighborhoods from short-term rental uses where the character of the neighborhood could be disturbed by activities that don't reflect residential uses. Special events, weddings, multifamilies and single-family homes, over-occupation, too much occupation of the house, too much parking for residential purposes, the variety of activities that go on are of keen interest in this ordinance. And the idea is that if it's single family, if it walks like a single family unit, it's got to talk like a single family unit. It's got to be plainly evident that this is a residential use. If it's not, this ordinance will kick into gear.
Yeah. And I'm going to stop you right there just because there may be some comments from members of the board. And, I think that we all acknowledge that, there is a place for short-term rentals. The concern is when it takes over the character of the neighborhood, where it is no longer acting like the rest of the neighborhood acts, and it has more of a commercial feel or venture, which impacts the single family residential neighborhood. And so from my perspective, this is one of the most important aspects of the ordinance as being proposed to the board is the limitation of use for non-residential purposes. And number two is that it maintains that single family resident feel, taste, smell, touch, and maintains the character of the neighborhood. So from my perspective, that is, one of the most important parts of what you have drafted, what you're recommending, and what we're reviewing now as an ordinance. So any other comments, questions from the board?
Yes, I have a question. Thank you. I know we've been going over the new ordinance and how it goes. Is there any way we can explicitly delineate the differences between the ordinance we already went through public comment on and this new ordinance and why it was necessary?
Supervisor Vasquez, we certainly can when we come to a public hearing. Which
Okay.
in the future we can explain to the public at that public hearing why we did what we did.
Not a problem. I knew the question needed to be asked. I didn't know if it was the appropriate time or not. So thank you.
Sure. And if I may, Madam Chair, I'll continue on, but I do want to just thank you for emphasizing this particular pivot point in the ordinance, because when we went through the exercise, Supervisor Vasquez, of rethinking what we were proposing, what we wanted to do is draw to the forefront, to the surface, exactly what we're trying to get at, which is the character of neighborhoods and the impact upon neighborhoods. So we just, in our redraft, brought that forward by stating it explicitly at the front of the ordinance in simple terms that people could understand. You might see in the next section, section 5 there, we address those things that we don't want to see in the single family or in the residential zones, which is a special event, multifamily transient stays, or any gathering that would otherwise require a county special use permit or a temporary permit or a county health code license or any other license or regulatory permit pursuant to some other county ordinance or state law or rule. So, you know, we say what we want to see, and we tell people what we don't want to see. And that's laid out at the front end of the ordinance.
Thank you for that. I just wanted to say that you answered my question enough that it's not necessary for more details. I think that's the piece that was still not explicit. And thank you for sharing with that. And of course, we can get to the details once we get to the public hearing. Thank you.
And Jay, I see you've got your hand up.
Madam Chair, thank you. And Vice Chair Vasquez, thank you. So I just want to real briefly let you know that when the public hearing comes back around, I think it'll be August 8th, I'll have the presentation flow the same as the ordinance does. So hopefully that'll streamline it.
And one other thing I'd just like to add for consideration is, and we're going to get to it when we get to the registration process, but given the fact that these are the two probably biggest things on our short-term rental ordinance, number one, that it looks, smells, and acts just like a short-term rental or like a single-family resident for single-family residential zoning, but also that it is not used for special events without the county special event permits. And that it would be good to consider in the registration process an attestation by the agent owner that in fact they have met the requirements for single-family residents pursuant to our definition. And number two, that they also acknowledge that this will not be utilized for special events, and they would have to go and get additional permitting if they're going to use them for a special purpose or special event.
Thank you, Madam Chair. We'll make that, Jay and I have discussed this, and we will make that explicit in the application form that the owner will complete when they register the property.
Thank you. All right, please proceed.
Thank you. At this point, I can move a little more quickly through the draft. The next section talks about judicial enforcement. We did not want you, in adopting this ordinance, to preclude yourselves from using other types of ordinances and procedures where we need to go to court and get an injunction. So we reserve to yourselves, the ability to go to court when we need to Superior Court, to seek injunctive relief, and to actually incorporate violations of the short-term rental ordinance in the other actions that we take to enforce public health, safety, and police regulations in those other spheres that we have. That's what section 6 is. Section 1.1C, you'll see definitions. Now, I'm not going to go through all these definitions. I think what I'm going to do is just highlight a couple of these, but this was a strong recommendation from the chair that we actually define our intentions at the front end of the ordinance, as we might in any other law where we start to want to regulate in a certain space. We've got to talk about we got to identify what we're talking about. And that's what definitions do for us. And so here, you'll see everything from the director to defining single family dwellings and dwelling units and family. The reason why we have those 3 definitions is, again, what we're talking about is neighborhood character. And what people of ordinary understanding can see and identify is how a house walks and talks and acts. So we ought to, and because we're pivoting our ordinance on the behavior of residential living, we identify what a dwelling and a family and a dwelling unit is, because that, again, is the crux point that we're going to hinge this ordinance on. We talk about registration regulations, identify what transient means under this ordinance. And so let's talk about verified violations.
Yes.
Verified violations is a term that's used in the state statute. And it's actually a defined term in the state statute. And the state statute defines a verified violation as a finding of guilt or civil responsibility for violating a state law or a local ordinance that has been finally adjudicated. But it doesn't define what final adjudication looks like. It's looking at the conclusion. Final adjudication is not talking about a process. So we took the liberty to define the process that leads to verified violations. And so we defined it in here. And what you'll see in the ordinance, and what's important for the definition of verified violations, is a distinction that we're drawing between registration violations and all other violations, such as sex offender registry and felonies committed on the site, and some of the other substantive areas of regulation that the ordinance allows. We address them, but we make a distinction between the two. And the reason why we make a distinction between the two is that we want to encourage the registration of short-term rental units, and we want to be able to easily enforce against those who fail to register, as opposed to the types of violations that might actually require a hearing officer to decide. And so we took the liberty in this ordinance to define the difference in verified violations from the ones that Jay Crystalman can verify from his investigation at his desktop, from the ones that Mr. Stento, our zoning enforcement officer, or the sheriff's department might define by some other further investigation. So again, the term was not defined, final adjudication was not defined in the state statute. So we went ahead and defined it for purposes of this ordinance. And you'll see there some of the distinctions in language that we drew between the types of administrative violations that Jay can identify at the desktop from the field investigations that the zoning officer or the sheriff's department might identify in the field. So I want to move on from definitions unless there's any questions.
Just, Madam Chair,
Any other comments, questions, members of the board, or we'll have a move on?
Madam Chair, if I may.
Yes, please.
So, and I think just a piece, you've noted it earlier and you're noting it now, Bill, but this clarification also helps for the process itself. There are appropriate areas where it goes through potentially a hearing officer versus where it would go to court. We know our hearing officer process may ultimately go to court, and when appropriate, it modifies that. So we have a more practical approach to when it is appropriate to go to court versus the hearing officer. And, I think I'm interpreting that correctly, but, please clarify if not.
Yes, Supervisor Ryan, you are interpreting that appropriately. And I think it has to really from a design standpoint, when we're talking about the ordinance, to distinguish between things that can be easily resolved and other situations that require more work. And that was part of introducing some type of ease of administration into the ordinance. And we really shouldn't be arguing about simple things that are very clear. Let's litigate the issues that are real disputes. And so we utilize the definition section to make that distinction, and you'll see it later in enforcement. I do want to comment for a moment on a suggestion that we received to include a definition of what prima facie evidence means, because we will be using, indicators of violation that are common to people. We live in an age where citizens possess cell phones, and they'll pop out the cell phone and take a video, or they'll pop out the cell phone and take an audio, or they'll create documents, or you may have a 911 call where someone's calling to ask for assistance and we want to introduce the tape or the body cam or any other variety of evidence that citizens who are complainants may want to introduce to the hearing officer or the director of the Department of Community Development. All of that evidence comes into consideration. And what we'll do is incorporate a definition of prima facie evidence so that the public can understand what it is that we can have, that we possibly can base our decisions upon when we administer the ordinance. So prima facie evidence will be included, not excluded. And it takes into comprehension all the different ways that our community comes forward with a complaint. Now, that also, in fairness to the party that's being complained against, we'll consider that evidence as well. So it's not precluding, a fair introduction of evidence. And prima facie can work in both directions. It only requires what evidence is credible. So we'll have ample opportunity for people to make their case either way. That definition doesn't appear in the draft that you have, but we'll incorporate that by the time of the public hearing. The next section is site management requirements. It's important to identify access. I mean, that's become an issue to many of these uses where there's an overabundance of vehicles, whether it's ATVs or guest parking. We still need to have emergency access, ingress, egress to these units. And so that is a site management requirement. Several of these other site management conditions come straight out of the state statute. We didn't invent these. They are language in the state statute. So we didn't independently think that we needed to prohibit the use of rental for housing sex offenders or maintaining sober living homes or felonious criminal activity on site. That comes straight out of the state statute. So we incorporated it directly.
And I think that's important to note because I know I have, and I know other supervisors have gotten some questions as to what do we have against sober living homes? And we have nothing against sober living homes. It's that, in fact, this is just incorporating the provisions of the statute. So
That's correct. The next section is the registration and annual permit renewal requirements. This ordinance is drafted in a way that what we seek is voluntary compliance. So what we wanted to do in drafting this, and this is really with Jay's help and his department, is to make it easy for people to comply with this ordinance and comply with the law. So we've set out what those registration requirements are. Some of them are mandated by the state statute. And you can see a list of what they are in the initial registration requirements. So again, this is balanced towards seeking voluntary compliance and nudging people who are non-compliant into compliance. And the information is laid out in the ordinance. Now, rather than enumerate all the things that you might want to require, what I utilized in subsection 4 is language that says using a form provided by the director. Right? So rather than enumerate all the things that registration needs or requires, the director is going to enumerate all the things that registration requires, incorporating at least these things from the ordinance. And so when we talk about attestation, what we'll do is we will include language about attestation that the property shall only be used for residential purposes. And I'll add that to the list of requirements in the ordinance to be perfectly clear. But Director Christelman will organize all of that information in a registration form that he'll design. So that's the meaning of item number 4. And you can see the various details in subsection 1.1e. Finally, to note, these registrations are personal to the owner. They don't run with the land. So in other words, if there's a purchase and sale of a short-term rental, the new owner, should they want to continue that activity, has to come in and re-register. So the STR license permit that you issue does not run with the land. It will expire upon sale, and the new owner will need to re-register. And you'll see that language repeated using a form provided by the director through this section. One of the interesting things, and I think this is about consumer protection, I was talking about that at the front end, the type of activities you might take to protect the renter. The owner has to display the permit that they receive inside the unit, so that any consumer of short-term rental will know that the owner has registered and complied, and that must be on display in the unit itself.
So I have a question, Bill, here on number number 6 on there.
Yeah.
At the end here, that the form will include, of course, contact information for the owner designees who's responsible for responding to complaints or emergencies in a timely manner. Can we put something in there making it clear what is a timely manner within 10 days, within 5 days, so that we aren't arguing over whether it was timely or not?
What is the board's pleasure on that? Because we can be specific, that can be included, but I think the intent here, and Jay, you may want to help me out. If your department receives a complaint about an activity that's ongoing, or perhaps the sheriff's activity receives a complaint about noise, I think the intent here is to contact that individual immediately and have them be available to go to the property and, address the complaint. So, Jay, what's your thought with regard to that requirement?
Read that again too, Bill, because what we're talking about there is the contact information. You're provided to provide the contact information, who's responsible. So it'd be for both. You know, when do they need to let you know by, and when, what's the time? We need, in my opinion, we need something. So Jay, whatever you think, but I think we need something.
Sure, we actually currently have that requirement as part of the draft application right now, so that we have the contact information as well. But as far as the rest of the fields, it's just an attestation, to use that word, that they have provided it to the patrons. But I'm
My concern is if we do not say when the owner who is responsible for responding to the complaint or emergencies in a timely manner, it could be 30 days and he's going to be arguing that he or she replied timely, is what my concern is.
Right, and Madam Chair, that's absent in the state legislation. So I'll work with County Attorney's Office to continue improving that.
And Madam Chair, I might suggest, Jay, that we look at subsection 1.1D, site management requirements. Because responding to a complaint is really about site management. So why don't we take a look at introducing a subsection 3 in site management requirements that addresses the need for the property contact to respond, and we'll put some timing in there that seems reasonable, and we'll bring it back to the board for the public hearing.
Perfect. Thank you.
Just making a note, and Jay, we can take a look at that. We'll call it site response requirements, and it's part of site management.
Okay, I'm jotting all of this too down also, Bill.
Subsection F of the ordinance requires the Department of Community Development to respond within 7 days to a permit application. So the idea is to be timely on our end.
Yeah.
But then there are provisions in here that specify when a permit application can be denied by the director. Sometimes applications are incomplete. Sometimes fees are not paid. Sometimes an owner may have prior verified violations or prior suspensions. So there's reasons why the director may not issue a permit, and it's specified in the ordinance, but it's put in a positive way. The director shall respond with a permit in 7 days unless there's the following types of violations. So we stated it positively, not negatively. The next section is citation procedures. This is part of that. If you recall, when I introduced the ordinance originally today, that we wanted to make a distinction between things that are easy to adjudicate and things that require more process. And so when it comes to registration, citations for registration violations, the procedures are laid out here, and they allow for the director to make a more prompt determination that a person has failed to register. And as to those, the prima facie evidence will utilize that definition to include the fact that the director may actually be able to take a look at the transient lodging on marketplace websites to identify the types of units in Coconino County that are available for short-term rental, and he can compare them against the book of registrants and determine who's not registered. and begin a citation process in that manner. And I believe that the way the director might express his enforcement of this provision is to positively nudge people into registration. This is intended initially to be a friendly process so that what we achieve is compliance. We're not looking for enforcement, we're looking for compliance. And for at least an initial period of time, we'll encourage people to do so. But we're not going to hamstring the director with extensive investigations in order to establish conclusively, or beyond the reasonable doubt, as we might say in the criminal law, that a violation exists. No, he can collect this credible evidence and make a determination of registration violations just from what a reasonable person would do as an administrator. So that's included here. And they can make their own investigations into allegations. They can also receive and investigate complaints from others and make the necessary inspections to provide for compliance or to seek citations as necessary for enforcement. They'll keep comprehensive records and make notes. They'll receive reports from other county departments. This could include the sheriff's office, but it also could include environmental health and public works, for instance. And having done that type of investigation for registration violations, they can issue citations. If it's more complicated, there's further due process that's allowed in the ordinance. If it goes to formal citation, there's the requirements in subsection F here about what the contents of that citation would include and how the citation is served on the offending party. Now, one of the beauties in the way that the registration process works is that the director, Mr. Crystalman, will ask for electronic contact information. I'm thinking email, but it might be other types of electronic contact information that will be in the registration form. So when we go about the process of issuing a citation, the way that this ordinance is balanced is that service upon the offender is completed by an electronic notification with a citation. So we're going to use the registration form to complete the service of the notice of citation. Now, that doesn't prevent us from also posting a notice in the field, and that's what Mr. Stento, as zoning enforcement officer, might be accustomed to doing when he's doing a field investigation. Right, so you can post it on the property, you can mail it to the defendant, but we're also granting ourselves the latitude to serve the citation by email because we've got the registration, email registration in the form. So you'll see that in here. There's also alternative methods of service. And Jay and Madam Chair, members of the board, subsection H talks about registration violations that an owner will have 30 days from the issuance date of the citation to cure the defect. Madam Chair, we thought that was a reasonable period of time in consideration of the fact that if there's a registration violation for failing to have registered with the Department of Revenue for a transaction privilege tax license, we recognize that's an administrative process that's done by others, not by us, and it may take time. Mm-hmm. So we thought that was a reasonable period of grace to get your papers in order. But if you're obstinate or you refuse, there's a further citation process, a further enforcement process. Again, importantly, the last part of that just states that the failure to remedy these registration violations is conclusive upon the director's final determination, and there is no further hearing or appeal. Now, we shouldn't be hearing and appealing litigation over something as simple as failing to register. Right. The alternative is for the complainant to go directly to court themselves, and we'll be happy to meet them there.
And we're glad there's not an automatic appeal to the Board of Supervisors. We really appreciate that.
Right. Well, that was one of the major changes from the prior draft.
Yeah, through past experiences, certainly you're setting it up appropriately. Thank you.
Enough said. The fines section is straight from state statute. The failure to register has the imposition of fines, and that's also identified separately, but the fine is within the guidelines of state statute. And then it talks about payment of fines. It's paid to the Department of Community Development. Now, the next section is about suspension of vacation or short-term rentals. And this is the section that we believed required more due process because the accusations are substantial. And so is the penalty. You lose your license for a year or up to a year for having accumulated various verified violations and such. And so suspension we take more seriously, and we provided due process, including notice and a hearing. On the final page at item number 5, orders of suspension are appealable to the Superior Court by the defendant in that case, and we just identified the statute that allows an offender to go to court. And again, we're happy to meet them there, and there's no problem there. That's a review of the ordinance. So again, we've talked about the purpose. We've talked about the importance of residential uses. We've talked about the strong preference for voluntary registration. We've identified the difference between registration violations and more serious offenses. Registration violations are determinable by Jay or the director, and there is no appeal. More substantive violations will have a hearing officer process. The offended party can go to court. We're happy to meet them there. And that's a review of the ordinance. Thank you.
Thank you, Bill, and really appreciate you and your staff and also the county staff. I know Jay has been really involved in this, and Jess. So really appreciate all of your efforts to get this together. And I'm really pleased on the changes that have been made. I really like thinking outside the box of that of the thinking outside the box of the statute, and coming up with something that's easily understandable for our public and something that maintains short-term rentals and the appropriateness of short-term rentals, but also addresses the concerns people have with abuses on short-term rentals. So really appreciate all your work on this. Other board members, comments, questions on this? Supervisor Ryan.
Thank you, Madam Chair. And so this is an opportunity here. We're hearing this in public that we have an initial go of trying to write it based on the legislation, which was really cumbersome. And I should note and compliment our county attorney, Bill Ring, in really sitting down and coming up with an applicable, but appropriate ordinance that also reflects our zoning, reflects our other capacities that we function under, particularly noting the single dwelling unit, as you had mentioned earlier, Madam Chair, as well as Bill had. And the other piece of it is short-term rentals, when it came, it was a different animal on what we had done in the past. We understand they're here. And there are many good opportunities if done appropriately. But it didn't really have definitions, and it started to corrupt our residential zoning because it wasn't defined. I think with this ordinance, it brings it back to enabling for the sake of the short-term rental, but also protecting that residential quality of that particular neighborhood. So I think you did a bang up wonderful job here, Bill, along with everybody else working together, noting as well as the sheriff's office together with community development. The piece that I look forward to in seeing what this is we paused long enough to say, let's make this tool better. I think you really did. Now we have an opportunity between now and if we decide to move it forward on August 8th, that, and I hope we would do that we can get what has been put together. There will be other potential modifications, but what has been put together to provide an opportunity for further public access to this information. We already went through a time period with the last, the initial rendition of this. I think it'd be appropriate to provide that time for communities to see it. And so I love it. I like what's coming together. There might be a little other tweak here or there, but all in all, I think this is what's been asked of us. And as we've tried to put it in place, again, it's not punitive to those that are doing it. It's just setting boundaries on how it's done to make sure that it is done appropriately. And if there's a question associated with it, we have a tool that we can use with this. So, thank you, Bill. I really support what we're putting forward, and just want to hear from the other board members and see where we go after this. Thank you.
Hello, Madam Chair. I have something to say.
Sorry, I was on mute. Yes, please, Vice Chair.
Okay. Thank
Vice
you.
Chair.
I concur with Supervisor Ryan. I really appreciate this new ordinance. I really like the fact that County Attorney pulled out the intent of why we're doing this and made it in the forefront. I think that's really important. So that way it's very clear. And if, as was said, if for some reason we are taken to court for it, it's very defendable. So I'm comfortable with moving forward with this new ordinance. Thank you.
Other comments, Supervisor Begay?
Madam Chair, I just want to thank everyone, all the staff and Mr. Ring, for really working on this and I think, it's appropriate, to ensure that, our residents are out there and they're safe and, protected and whatever, this, the reason behind this ordinance. So I just want to say thank you to the staff. And then, I think it's going to really help out, to have some structure, regarding the short-term rentals. And I greatly appreciate that. So thank you, Andy, and your staff also. Thank you.
Other comments?
Madam Chair,
Supervisor Fowler?
thank you. Short-term rental has really, early on when short-term rentals came around, we did do an ordinance. And then the legislators decided that we didn't have that kind of authority. So now we're in another phase where we do have some authority that's been passed by the state legislators, and that's how this ordinance comes about. And it does not apply to the municipalities or HOA. And we'll have to do a lot of community education on the ordinance, on the process. but it's pretty much clearly laid out, or really the improve from the draft to now. It's really improved the how it's going to be done in Coconino County. I want to just recognize that the staff, our staff, and the community development and county attorneys and the public comment, that's where that's how public comments are used to improve the policies that the board decides to take action on. Really appreciate the public comments that have been coming in. We've received emails, letters, calls, text messages, however way that people can contact us, and we really appreciate that. Now we're going into another phase, another opportunity to make comments again. So I just want to thank everyone for making these comments and bringing your concerns and ideas to the board, and that's how we take these actions. So just want to thank everyone. So thank you again.
Thank you. And I know we also have a recommendation from our staff, which I would agree with wholeheartedly, and that is that because there are some substantive changes as well as an overall formatting change, that we need to go ahead and post this on our website, get it out on social media, and that we invite, once again, public comment and review, and that we have a public hearing on this. The proposal is August 8th. I think from what I've heard, the board in general has indicated an agreement on that. And then there would be a grace period to obtain the permit, and for staffing ability to get out there, do the marketing, do the public awareness, get the information out to the public. And if we do move forward on this and for our public hearing on August 8th, the ordinance and approve it, the ordinance would not go into effect for 120 days or until November 14th. So unless members of the board would like to entertain a motion, otherwise, I think it's appropriate to accept the recommendation of Jay Christelman and our administrative staff for a public notice and copies of this being placed on our website, and a public hearing proposed for August 8th, and ordinance going into effect on November 14th. So with that, do I have a motion on this?
Madam Chair, yes, I would like to make that motion, that we do set a date for public hearing of August 8th. And as outlined, as you stated, and just, following up and reading from this subject, the ordinance 2023-04 short-term rental ordinance pursuant to ARS 38-431.02. And so that's did I get that statute correct? No, that's the executive session.
Yes, executive session. I think you could just say the draft ordinance 2023-04.
Yeah. So just to have that, forget the statute. No.
So we have a motion by Supervisor Ryan to post this and to have a public hearing for additional public input and comment for August 8th. And then to accept the administration's recommendation that we have a 120-day grace period once we've approved this. And if we do that on the 8th, it would go into effect on November 14th. Do we have a second to that motion?
Second.
Second by Vice Chair. All those in favor of that motion, please signify by saying aye.
Aye. Aye.
All right, I think it's unanimous. And that's great. This has been, fabulous. I'm excited to get this out to the public. Hopefully also to share it with the city of Flagstaff, city of Williams, and other municipalities within Coconino County, and hopes to get their input and thoughts on this as we move forward. And look forward to our public hearing, public comments on August 8th. So any other comments or conclusory remarks?
Madam Chair, just reiterating, this is fantastic. Well done, Bill. And then the other piece is just a note, Madam Chair, after this, I'm supposed to be traveling, so I'm going to have to step away from the board meeting after this. Madam
All
Chair.
right, very good. Well, thanks, Bill, or thank you, Bill, and County Attorney's Office and our staff. Job well done. We'll move forward to the next step. And Matt, safe travels to you. And with that, members of the board, our next item is we do have interview of candidates for the communications director's position. And that is going to go into executive session pursuant to ARS 38-431.03A1. We are going to break before we go into executive session, but I need a motion for us to go into executive session for these candidate interviews. Do I have such a motion for executive session?
So moved.
Vice Chair has a motion to go into executive session for interviews. Do I have a second?
Second.
Second by Supervisor Fowler. All those in favor going into executive session for interviews for the communication director position signify by saying aye.
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 Supervisor Begay, you voting?
Aye.
All right, it's unanimous. So with that, we will go into executive session. It's going to take some of us a few minutes to get there. And so we're going to be arriving a little late, Andy, but I'm assuming you'll handle that. And I'll see you here for interviews in just a few minutes. So thank you so much.
Thank you.
Thank you.
I'm in the middle of, in the trailer,
Yeah,
in the middle of working on our shelf, so I'm almost done, I'm waiting for something to dry. If you need some help with, this is 4 o'clock, she needs some help, somebody to hand her some things that she needs to put up in her attic. And that's when Nancy, I can't do it now, but I can get back with you later about a time. And she said, well, I just need a time. And I said, Nancy, I'm in the middle of doing this thing. I said, I could definitely help you tomorrow.
Good evening, everyone. Can you hear me?
Yes, good evening, Vice Chair.
All right, long time no see.
Yeah, I got half of my signatures, our contract signed, so
All right.
I'll do the other half tomorrow.
Good stuff.
Yeah. We know that Matt won't be with us, so Judy said she was going to be there by phone. Hopefully we'll see Lena.
Hey, Chair, this is Andy. My laptop picked a terrible time to reboot, so I'm on my phone right now, and I'll get on my desktop just as soon as I'm able.
I see Supervisor Fowler is with us. I think we've got another minute to go. And I see we've got 3 of us on, and again, I don't know if we've found Supervisor Begay. I knew she was going to call in.
She is not on yet.
All right. All right, well, it is 6 o'clock. And all is well, at least so far. And we are continuing our board meeting. We met this morning. We had a special session this morning. And we had an executive session here around 1 o'clock. We are out now of executive session. We are back in open meeting. And a couple of things, we are going to go back and do a call to order, see who's all here with us this evening. And I'll start. My name is Patrice Horseman, and I am the chair of the Board of Supervisors and the supervisor for District 1. District 2.
Good evening, everyone. Jeronimo Vasquez. I'll change it up. Vice Chair, Supervisor for District 2. Thank you.
Thank you. And District 3 is not with us. Matt Ryan was with us this morning. He is on travel and he is not going to be able to attend tonight's meeting. And we have District 4 is, have we seen if Judy Begay is with us yet?
No, she is not present.
All right, so we'll reflect that she's not. When she, if you notice her coming on, if you could please let us know, Lindsay, even if you have to interrupt us, so that we know that she's with us. So
I will.
District 5, Lena Fowler. District 5, I see your name, Lena Fowler. She's looks like she's with us. Lena, are you with
there
us?
we are. Okay. For some reason, it wouldn't let me in. So anyway, hello, Madam Chair and others. This wonderful evening to have our meeting again. This is Lena. And yes, District 5. Thanks so much. And I'm driving, so hoping that it'll stay connected all the way through.
All right, Lena. Well, thanks for being with us. And we hope as well that you'll be able to fully attend. So we're moving on, and we didn't this morning do the Pledge of Allegiance to honor our country. So we're going to do it now. And so I'm going to ask all that can to please stand and let's say the Pledge of Allegiance. And Lindsay will put the flag on the screen and also the pledge for us so we can join in. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, thank you. And we are moving on, and the next is call to the public. And again, we didn't do this morning for our special meeting. We're doing it now. Members of the community, now is the time for you, members of the community, to be able to address the governing board. If you have questions or concerns or want to discuss matters that are not on the agenda, now is the time for you to be able to call in and to address the governing board. Since they are not on the agenda, that means, of course, that the open meeting law will not allow us to discuss them, but we can refer them on to administration to review, and or we can put it on an agenda item at an upcoming board meeting. And we ask you to keep your comments to approximately 3 minutes. And of course, this is an open meeting, so we ask that you, of course, remain courteous and civil. With that, I'm going to turn this over to Lindsay Daly to explain to members of the public how you can join us here to address the board. So Lindsay, please.
Thank you, Chair Horseman. At this time, if there is anyone that would like to make a comment, you can hit the raise hand icon that will appear at the bottom of your screen. If you hover towards the bottom of the screen, it looks like a hand. If If you click on that, that will raise your hand and notify us that you would like to speak. If you've joined the meeting by telephone, you can hit *9, and that will raise your hand and notify us that you would like to speak.
Members of the board now, or members of the community, now is your time. So please join us.
And there are no hands raised, Chair Horseman.
All right, members of the board and members of our community, this is the last call to the public. Please, members of our community, join us. So we look forward to hearing from you.
And there are no hands raised.
All right, then we're going to go forward with our meeting. And our next item of business is a proclamation. It's consideration and possible action to approve a proclamation designating June 19th, 2023 as Juneteenth Day. And I know we have a proclamation before us, and it looks like we have Erica Philpott, is that correct? From Human Resources, who's going, I do not see Erica.
So Erica is not going to be here today. She had another meeting. This is Carolyn Kidd.
All right.
She had a NAPEP meeting and had to run off, but I'll be here to read the proclamation.
Well, Carolyn, we are very happy and welcome to join us, and we're very welcoming to have you read the proclamation this evening. And this is an important day, Juneteenth. And I know that probably after you read the proclamation, I'm going to turn it back to you. If or what we're going to do is we'll have a motion and a vote on the proclamation. I'm known to forget to do that. So we're going to do that. And then after that, I'll turn it back to you, Carolyn, so that you can let us know some of the activities happening for Juneteenth. And then I'll turn it over to the board members for comments. So let's get going first, though. And Carolyn, please read the proclamation for us.
Thank you, Chair. All right. So whereas the Coconino County Board of Supervisors joins residents and local governments across the country in the celebration of June 19th, 2023 as Juneteenth Day, as a day of empowerment and resilience of Black Americans who have endured generations of oppression in the journey toward equal rights and opportunities in America. Whereas on June 1st, 1863, President Abraham Lincoln issued the Emancipation Proclamation, setting in motion the end of slavery in the United States, recognizing and securing a law of the right to freedom for every enslaved person. Whereas on June 19th, 1865, Union Army General Gordon Granger arrived in Galveston, Texas, and presented General Order Number 3, announcing that all enslaved people were now free, more than 2 years after the issuance of Emancipation Proclamation. Whereas from that day forward, June 19th has been a day of celebration, prayer, and reflection focused on the history, adversities, and victories of Black Americans throughout the United States. Whereas the celebration of the end of slavery, which became known as Juneteenth, is the oldest known celebration honoring the end of slavery in the United States, honoring more than the end of cruelty of bondage, but the resolve of the human spirit over generations of adversity. Whereas the celebration of the end of slavery, whereas the celebration of Juneteenth reminds each of us of the promises of freedom, equality, and opportunity, and serves as the reminder for the further progress we must make towards racial equality. Whereas in 2021, Juneteenth was established as a federal holiday, opening up to global interpretation and providing a better understanding of the evolution of our nation and its people. Juneteenth celebration then, like now, recognize the ongoing fight for human rights and equality and are commemorated through family cookouts, faith services, musical performances, and storytelling. Whereas we welcome the commemoration of Juneteenth as a day of reflection to honor the progress we have made, acknowledge how far we still have to go, and renew our commitment to building a community vision of advancing justice, diversity, equity, and inclusion for all people in the Coconino County and beyond. Now, therefore, be it resolved that the Coconino County Board of Supervisors do hereby designate June 19th, 2023 as Juneteenth Day to honor, recognize, and celebrate with appropriate programs, ceremonies, and activities, thereby strengthening us as a county, state, and nation forever. Thank you.
Thank you, Carolyn, for reading the important proclamation. And with that, I am going to ask for a motion. Do I have a motion?
So moved.
We have
Second.
We have a motion and a second designating June 19th as Juneteenth Day and accepting the proclamation as read by Carolyn Kidd. All those in favor, please signify by saying aye.
Aye.
It is unanimous. And thank you so much, board members. Carolyn, would you like to let us know some of the activities that are taking place?
Sure thing. Thank you so much, Chair. So there is a flyer I have here. Let me go ahead and share this flyer. Can you see it? I'm sorry.
Now, yes, it's coming up.
Okay.
There it is.
All
Thank
right,
you.
awesome. Okay, so with a couple members of different organizations in Coconino County, and you will see the logo at the bottom. We have the NEU, also Toyota Findlay, APS, also LBE, which is a Live Black Experience organization, and together with ADAC, which is our African Diaspora Advisory Council, and also with SCA. They come together and we're having we have three different celebrations. So the first one is on Saturday, June the 17th, and it is at South Beaver School. It's a free event and it's from 10 a.m. to 4 p.m. And then we do have a second annual Juneteenth on Friday. It is a nice gala or dinner at Doubletree by Hilton. Tickets are $50. And then the gospel concert is on Sunday afternoon at Church of Christ in Flagstaff. And that's a free event from 5 p.m. to 7 p.m. and all persons are invited. Thank you.
Thank you very much and really appreciate that for that invite. I know many of us are going to be taking part in those events and we appreciate you inviting the community to them as well. So thank you.
Thank you so much.
With that, I'm going to turn this over to my board members for comments or anything you would like to say on Juneteenth. And I see Arena, you're up here too. Is there anything you would like to say about the Juneteenth events before I turn it over to the board?
There we go. Not anything at the moment, but thank you, Chair, for including me. Just that I know on ADAC's behalf, they would really like to just invite everybody to these events, and they work really hard to make them free for the public. So yeah, if you have time this weekend, please make it out. And thank you, Carol, for reading the proclamation and for the board for recognizing it.
All right, thank you very much. And so members of the board, any comments you'd like to make in honor of June 19th, Juneteenth Day?
Sure, I'll start.
Yes, Vice Chair.
Well, thank you. First off, I just want to thank everybody involved in putting together this proclamation as we take this opportunity to reflect on the importance of Juneteenth in our country and how how important it is for us to think back and look at how things were and how things are the way we want to be and how much work we have to get there. And so, I really, the proclamation really resonated with me on the part about reflection, about where we've come from, but also where we need to go and how much work there's still to do. And so I just want to say thank you to the team that put this together and to continue those efforts. We need to take every opportunity that there is to constantly reflect and constantly improve, human slavery has no place in human society, and these declarations are ways of reminding us of that, because sometimes we forget that human element of what this really implies. This is celebration and we're excited and happy that, at that time of the end of slavery, but you think about that for us as we're reflecting it, and in our lives, what something like that would mean, and so it's really important that we give this day the respect and the energy that's due. I really hope people participate in the different events, really look to learn and reflect together and see how we can move forward, because at the end of the day, it's about the common good and what kind of society we want to live in. And so I just really appreciate that emphasis on diversity and inclusion and looking for equity for all, and seeing how we can start addressing some of the issues that still linger, because the work's not done. We're not there yet. We'd like to think we're getting better, but there's still a lot of work to be done. And so thank you for bringing this forward, and I look forward to the celebrations. Thank you.
Thank you, Vice Chair. Supervisor Fowler, do you have some comments you'd like to make?
Thank you, Madam Chair. And those that put this proclamation together, it is really important to think about where we are as a society, and even in our own county government, and how we need to continue to work together. And we can't just talk about it. We need to actually really make sure that we all think about each other, and that our policies and our daily decision making is reflective of these kinds of proclamation, and making sure that we are all one family, as we always say. So I just want to thank everyone, and thank you for reading the proclamation and bringing it to the board. It is so important that we recognize all of these, and then remember the history that we come from. We can't just say that this, band history. We have had a very traumatic history, and how do we talk about it? How is it that it's okay? How do we make it okay to learn about the history, and then learn from it and become better people? So thank you so much.
Thank you, Supervisor Fowler. And yes, thank you, Carolyn, for reading the proclamation. And yes, it's always absolutely important that we resolve to do better, to be better, and we can do and be much better with the progress that has been made, but there is still so much more to do to bring equality, justice, and inclusion to our society. So I appreciate this proclamation. I appreciate the June 19th, Juneteenth Day celebrations, and I plan to be there and plan to take part and to learn. So thank you so much. Really appreciate it.
Thank you so much, Chair.
All right, we're going to move forward, and our next is our consent agenda. And members of the public, our consent agenda are items that are more administrative or ministerial in nature. They can be handled through one motion and through one vote. However, these items on the consent agenda are not set forth for individual discussion or individual vote. So we leave it up to the board. If the board would like to remove items from the consent agenda for individual discussion, which will then require an individual vote, now would be the time to remove the items. And we're looking at items 4 through 10. And with that, I am going to request that we do remove items separate from the consent agenda for individual discussion, item number 6 for United Way of Northern Arizona, and number 7, a budget adjustment for the Coconino County African Diaspora Advisory Council. So removing 6 and 7 is I'd like to separate. Any other separation from the consent agenda?
Madam Chair,
Yes, Supervisor Fowler.
I like to separate number 9 just for information. Thank you.
Very good. And number 9. So with that, I'm going to ask for a motion to accept the consent agenda items 4, 5, 8, and 10. Do I have a motion?
So moved.
Motion by Supervisor Fowler, second by Vice Chair. All those in favor of accepting the consent agenda, please signify by saying aye.
Aye.
Very good. Consent agenda is in fact passed. Now we're going to turn to item 6, consideration of possible action to approve community grant funding to United Way of Northern Arizona in the amount of $5,000 from District 3 and $5,000 from District 1 and $5,000 from District 2 for a total of $15,000 to support Kinder Camp, a program delivered within Flagstaff and Williams Unified School Districts, which is designed to help children with foundational, social, and academic skills necessary for a successful transition into kindergarten. And I know Kinder Camp has been with us here on Coconino County for quite some time. It's been a very, very successful program. Many of us have been able to attend a Kinder Camp and see the children, working so hard to get ready for kindergarten. And we have had the honor of putting some money in to continue to fund the Kinder Camp program. And I also see we have Liz Archuleta with us, somebody who's near and dear to all of our hearts, and somebody who used to be our on the Board of Supervisors for many years. And I know she's with us. And Liz, would you like to say something first? And then we'll go ahead and take a motion and turn it over to the board.
Thank you, Madam Chair. Thank you, members of the Board of Supervisors. Just wanted to take a few minutes to, first of all, thank you for your consideration of this item, and wanted to just provide a little bit of insight into the Kinder Camp program. You're absolutely right. Coconino County and the Board of Supervisors have been strong supporters of the Kinder Camp program, but for the public's awareness, Kinder Camp is a program, a trademark program of United Way of Northern Arizona, a signature program that is an immersion program for 4 and 5-year-olds who are immersed in a summer camp where they can experience what kindergarten will be like. And the purpose of the program is to create this home to school partnership and bridge so that kids are better prepared to enter kindergarten. And we promote literacy skills. We create an awareness of process and procedures in the classroom. We, of course, talk about appropriate behavior and model appropriate behavior for the kids so they can focus on their academics. And also teaching kids, how to work with others, their fellow students in the classroom. We really focus on phonological awareness and literacy skill development, which includes beginning word sounds, lowercase alphabet writing, letter sounds, and teaching the kids how to write their names. And today I went on a tour and got to see kids who were learning how to use those big fat pencils that we all probably used in kindergarten, and learning how to write. And some were practicing the letter N, others were practicing numbers. They all were really engaged in their different centers. And what was clear is that there was a lot of learning going on. And even from when I saw them the first day last week, the learning and the development of the kids that had taken place just in a matter of 7 days was astounding. And so I know that some of the members of the Board of Supervisors are signed up to take a tour, and I'll just want to thank you very much for doing that. For those who haven't signed up, we do have a tour tomorrow, June 14th, next Tuesday and Wednesday, the 20th and the 21st. And then the best thing ever is the graduation ceremony where they bridge over to kindergarten, and that's on June 29th. And the board is invited to attend any of those events. But again, don't want to take a lot of time, but rather just express my appreciation on behalf of the children in Flagstaff and Williams. We have 8 classrooms of children in Flagstaff, and we have 2 classrooms of children in Williams, and they are all, bustling and seeing you'll see a lot of learning going on in those classrooms. So thank you for your consideration.
And thank you for all you do. And I was able to change my calendar to make sure I get there to see Kinder Camp this year. So really appreciate what you're doing, Liz. So with that, I'm going to entertain a motion to approve our community grant funding to United Way of Northern Arizona for the Kinder Camp program as outlined by Liz Archuleta. So do I have a motion?
So moved.
Do I have a second? I'm going to second that motion. And all those in favor of approving the community grant funding for United Way, please signify by saying aye.
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 It is unanimous. So thank you. And Liz, again, thank you for all you do. I'm really anxious to get over there. So appreciate it.
Thank you so much.
All right. And we are moving on. We've got item number 7. This is consideration of possible action to approve a budget adjustment of funding in the amount of $500 from District 1 and $1,000 from District 2 Community Initiative Funds for the Coconino County African Diaspora Advisory Council for the expenses for the 2023 Juneteenth community event. And we got a little background on that from both Arena and Carolyn. And I can tell you it's my pleasure to help to contribute towards this event. And at this point, I'm going to accept a motion and a second for the approval of the budget adjustments for funding as set forth.
So move.
A motion
Second.
by Supervisor Lena Fowler, a second by Vice Chair Geronimo Vasquez. All those in favor, please signify by saying aye.
Aye.
It is unanimous, so thank you. And we are moving on to our last consent agenda item. This is consideration and possible action to approve the Arizona State Parks Project Sponsor Agreement number 782305 and associated budget adjustment in the amount of $270,000 and approve the purchase of a jet boat to replace Sheriff Office's existing 23-foot Koffler boat and trailer plus 2 jet skis and trailer using the GSA 1122 program to continue law enforcement boating programs on Lake Powell. And I know that is in Supervisor Supervisor Fowler's district, and Supervisor Fowler has asked to have this removed. So Supervisor Fowler, I'm going to turn this to you and you might have some questions.
Madam Chair, I actually don't have any questions. I just want to see if the Sheriff's Department might be able to talk a little bit more about this important program. I think people sometimes don't realize that we do patrol and work on Lake Powell at the Arizona side. So I thought that it was just a great opportunity for education. It's a wonderful program. Thank you.
Thank you, Supervisor Fowler. And I see Brett Axland is there. So Brett, can you give us a little background on this?
Yes, thank you very much, Chair Horstman and Supervisor Fowler. The Coconino Sheriff's Office has had the privilege of patrolling our lakes and waterways within Coconino County for several decades now. This is, as you can imagine, not a cheap venture, as we have several boats. We have Lake Powell in District 5. We also patrol the Colorado River below the Grand Canyon Dam down into the Grand Canyon. So in order to be able to do that, we do receive funding through the legislature from boat taxes and boat registrations to be able to purchase vessels, as well as 2 full-time boat officers that are deputies in our Page substation. So this particular boat, replacing our Koffler 23-foot jet boat, is mainly used on the Colorado River, running the rapids at very low water levels. So we are very happy to receive this funding to be able to replace that boat, which is about 20 years old, and purchase another one that we'll be able to use on the Colorado River, as well as Lake Berry at times during the summer busy days. So thank you very much. We do have several education programs that we run off of our boat patrol program, one of which has recently been supported by Supervisor Fowler, which is our I was caught by the sheriff campaign wearing a life jacket. So we issue these to children that we do catch that are wearing life jackets. It's a very proactive and very positive campaign that we run. So those are some of the things that we will do. So thank you very much.
Thank you, Brent. Thank you for the overview on your important program and obviously monitoring and enforcing there at Lake Powell. So and Colorado River. So thanks so much. And with that, I would entertain a motion on this, and I'm going to turn to Supervisor Fowler to make that motion.
Thank you, Madam Chair, and thank you, Brett, for bringing the information to the public. It is just such a wonderful program that is out on the lake. So with that, Madam Chair, I move that we approve item number 9 as you read earlier.
Thank you. We have a motion by Supervisor Fowler. Do I have a second?
Second.
Second by Vice Chair. Do all those in favor of approving the Arizona State Parks Project Sponsorship Agreement and associated budget adjustment as read, please signify by saying aye.
Aye.
It is unanimous. So thank you. We have completed our consent agenda. We are moving on. We now must resolve as the Flood Control District Board of Directors. And with that, I'd entertain a motion to do so.
I move that we resolve as the Flood District Board of Directors, Madam Chair.
We have a motion by Supervisor Fowler. Do we have a second?
Second.
Second by Vice Chair. All those in favor of resolving as the Flood Control District Board of Directors signify by saying aye.
Aye.
It is unanimous. We are now the Flood Control District Board of Directors. And we have 2 items for consent agenda. As I said, these are usually administrative or ministerial in nature. And these are not usually for discussion items unless we remove them from the consent agenda. So I am going to ask if there is anyone that would like to remove either item 11 or 12 from the consent agenda. I'd like to remove item 11 for discussion, so I'd like to separate that from the consent agenda. Any other removal? If not, I would entertain a motion to accept the consent agenda item number 12, which is to approve budget authority and expenditure limit increase to the Flood Control District in the amount of $150,000 for the Natural Resource Conservation Services Award, agreement number NR 239457. 0000 C001, amendment number 1, to allow the Flood Control District to complete neighborhood mitigation efforts in the Copeland and Peaceful Way flood corridors for fiscal year 23. Do I have a motion?
So moved.
Motion by Supervisor
Second.
Fowler. We have a second by Vice Chair. All those in favor of approving the Flood Control District consent agenda, please indicate by saying aye.
Aye.
It's unanimous. So we're going back to number 11. Number 11 is consideration and possible action to approve a budget authority and expenditure limit increase to the Flood Control District in the amount of $2,591,841.57 in reference to the relocation of funds available to specific accounts related to the general fund loan of $15,500,000. And this is in our packets on item 11, which has gone into some detail and goes into the background on this, and also the two discussed options on this. And I know that Lucinda Andriani is on travel, but Sean is with us, Flood Control District Business Manager. And I also think we also have is Siri with us? Siri was supposed to be on for this evening as well, in case we had questions. And hopefully we can find her. But with that, Sean, would you mind explaining what this is about and what the two options were and why there's a recommendation being made?
Absolutely. Good evening, Madam Chair, members of the board. Thank you for allowing me to be here to present this item. Basically, what we're looking to or requesting from the board is there were two options that we submitted for review with Finance Director Siri Mullaney, and really what we were looking for was guidance in terms of how we wanted to handle what actually ended up being unplanned revenue for the accounts that were tied to the general fund loan from the board of directors. Essentially, what we did was throughout the emergency response period of the Schultz pipeline and Schultz pipeline flood events, we had requested from the board $15.5 million loan to be used for expenditures related to those events. One of the things we did not plan for at the time was the possibility of reimbursement from the Department of Forestry and Fire Management, DFFM. So we moved forward with some of these expenditures. As a result, we did find that some of those expenditures did meet reimbursement criteria. So we were able to go ahead and submit for reimbursement those costs. As a result, those costs did come back as unplanned revenue. That is revenue that came in to pay off the loan. Now, part of the agreement with the loan was that we did allocate and plan a payment process over the 5 fiscal years annually, a repayment process of about $3.1 million beginning in fiscal year 25, FY25. So when we realized that we did have this unearned revenue, our conversation with finance was, would we like to go ahead and apply that revenue to the loan repayment and in essence pay down the loan early, thus allowing us to reduce the payment amount annually starting in FY25? Or per the recommendation of the finance team, did we want to go ahead and stick with that 3.1 million annual payment beginning in FY25 and just reallocate some budget authority to offset that unearned revenue? So needing the cash flow to help complete the projects that are currently ongoing in the Schultz pipeline area, it was the recommendation of the finance team to go ahead and request that we go ahead and ask for that additional budget authority for FY23 to complete these projects, knowing that we still do plan to pay the full 15.5 with the 5 payments of the 3.1 beginning in FY25.
So I have a couple questions, Shauna, on this, and then a comment. But my questions are: why was option 2 preferable over option 1 from finance? I mean, I can see why it might be preferable for the flood control district, but why would finance make that recommendation? Does it in any way, shape, or form have anything to do with the expenditure limit? And does it?
No.
So
I'm sorry.
Okay. So
okay.
Go ahead.
Oh, I'm sorry, Madam Chair. I apologize. No, so because this is more of an internal movement of funds, this actually does not impact anything related to the expenditure limit. That 15.5 was allocated early on, and so we're not asking for an increase to the loan. And instead, we're asking more of an administrative in nature allocation of use of funds, knowing that that 15.5 has already been budgeted for both the general fund as well as the flood control district. So this does not impact the expenditure limit.
Good. And then why then does this matter to finance which way we go?
I think the reason, and again, I think Siri could speak more clearly on this, but the reason is it's really for cash flow purposes.
For the flood control district.
For the flood control district, correct. As we get towards the end of the fiscal year, finance has already allocated a dollar amount to be carried over from this fund to be used in FY24. So it was Finance's recommendation that we go ahead and apply it to FY23. So we don't have to tap into what's already been budgeted for FY24 in the carryover process.
Okay. And then the other is, what is the interest rate for the loan repayment to the general fund from the flood control district to the county's general fund for this 15 million?
That I'm not sure, Madam Chair, that would be a question for Siri. I'm sure she knows the answer to that. If there is an interest rate, from my understanding, I don't know if there is or not, but that would be a question for Siri.
Okay. And I don't recall there being any interest to it. So in some ways, the way I look at it, and correct me if this is just an oversimplification, John, but the way I look at it is the two options are to go ahead and pay that loan now, repay it because we got the money from DFFM, to pay it now, or to keep it in the flood control district, kind of an interest-free loan, if you will, that we would not start paying back for the next basically year and a half.
Yes, so what we're looking to do is, again, we could have used these, unplanned reimbursement funds to pay down the loan. But I think what the thought process was is that that would reduce the amount of the loan, which would reduce the amount we can actually spend towards the expenditures related to the Schultz pipeline event.
Right.
So rather than do that, we wanted to have the full 15.5 available, knowing that we were going to need the cash flow for unplanned expenditures related to some of the work being done out in the flood area.
And we, the board, have already authorized the funds. In other words, this would be an additional $5 million that we have not, as a board, authorized to be spent for the flood control mitigation work.
Well, this isn't necessarily an additional 5 million or 2.9 million, I believe. This is actually still under that 15.5.
But you got the money twice, right? You got the money from DFFM.
Yes.
Okay, so you got the money twice. So it is an additional 5 million. I just want to make it clear where we are.
Okay, yeah.
Okay.
Yes, I see what you're saying.
So, and we, the board, have not allocated this additional 5 million, if you will, to be spent for additional flood mitigation.
No,
Certainly, it's not on the budget that we all looked at from, during our budget process.
Correct.
Okay. So we would have, if you will, follow me on this. We would have an additional 5 million somehow, somewhere, at some point, that could be spent for any purpose within the flood control district. That authorized by the board, obviously.
Yes.
Okay.
Yes.
All right. Thanks. All right. And your recommendation is for us to accept option number 2, which is, of course, to keep the money within the flood control district, that 5 million, and then to pay it off as we originally were planning to do in 25, 26, and 27.
Yes, 25 through for the 5 annual payments starting FY25. Correct.
Thank you. Any other comments or questions from members of the board?
Yeah, just still processing, because to me it seems like trying to figure out why it's not to our advantage to use this money to pay off some of that loan sooner rather than later. And I know you talked a little bit about it, but it's still not quite clicking. Can you explain that for me a little better, of why it's to our advantage to hold on to this $5 million rather than use it to repay the loan at this time, or at least a part of it?
Again, I think that is more of a question for Siri, but from my understanding, Supervisor Vasquez, the reason that we're doing this is for cash flow purposes. We could go ahead and pay down the loan, but that will reduce our capacity to be able to utilize funds assigned to the flood control district as part of that 15.5 million. It would also impact the flood control district's 10-year plan, and we would have to go back and recalculate how much we would actually have to reduce the payments by for each fiscal year starting in 25. which I believe is an option. We could go ahead and go back and do that and pay that down. But essentially what would happen is we would then not have that 2.9 million available to the flood control district as additional capital to cover some of the expenses that we're seeing with some of the mitigation work that's being done in the area.
Okay, I appreciate that. Thank you for that, for taking us through that. And then my next question is, based on the allocation of this funding, are there any other projects besides the Schultz pipeline projects on the flood control district that may be eligible to use this funding?
No, Supervisor Vasquez, the funding from the general fund loan, the 15.5 million was specifically allocated for Schultz pipeline response and recovery mitigation work. I don't believe that the board authorized us to use those funds in any additional projects.
So, and this is where I have some problems. And Vice Chair, do you have any follow-up? Because I don't want to interrupt you if you want to.
The only other comment I got to make is, Sean, I appreciate your explanation, but I really feel like finance needs to be here in order to make that decision on what to do on this, because I feel like we have a little bit of incomplete information. And so I'm digesting it still. I don't know if is the necessary to do action right now, especially considering we only have 3 of the flood control board members on, and then we don't have finance here. So I'm just trying to sort through it and digest it some. Thank you.
And let me tell you what my concern is it may be money that we want to, as the flood control district board of directors, that we may want to allocate in addition to the flood mitigation, but this is over and above what we've already, if you will. This is another 5 million. So and I know that we have also talked to the flood control district administrator that we want to have a meeting to go over what used to be our priority projects before we had 2 huge wildfires and over 50 separate flooding events, and to really take a look at what we had originally planned as a flood control district priorities and monies for those priorities, because it may be that, depending if it's a prepayment, if you will, not earlier payment, we could still make a loan back, or we, the board, could vote for this $5 million to utilize it for more than just the Schultz mitigation purposes. So, I do, certainly we want to get this project on flood mitigation done. I want it done. You all are working so fast to make sure we get this done, and we so appreciate that. But I think we also need to take a look at the other projects that were in the hopper, if you will, for the flood control district before we had all these emergencies. And see what's the highest and best use for this money. So that's just my thoughts. Supervisor Fowler, do you have any comments on that?
Hello, Madam Chair.
Yes. All right. And I did hear, by the way, that Judy is not going to join us this evening. So it's just going to be the 3 of us. Sean, does this decision need to be made now, or can we hold it to the next meeting?
I think we can go ahead and hold this to the next meeting. I would prefer Siri to be here as well.
Yeah, and I actually thought Lindsay had asked Siri to be here because we were hopeful to get it done too, but it'd probably be good to have something must have come up. So it'd probably be good to, if we can hold off on this, Sean, I'd like to.
Sure. Yes, that'd be fine, Madam Chair.
All right, very good. Is there a motion to table this until the next meeting?
I think we lost Lena, so I'll make the motion, but I don't know if we have 3 of us.
If we've lost her, we've just lost our quorum. Lindsay, can you see if we can get Supervisor Fowler back?
There she is.
She's here. She just dropped off for a second.
That's kind of why I was just
Madam Chair, I'm back.
Thank you. Thank you for being back. And Supervisor Fowler, you know, you're our quorum. We've only got the three of us. So we need us all. So
I have taken a route where I'm gonna have connection, hopefully all the way.
All
So,
right.
on the flood district, I believe, I was wondering if this was time sensitive for one. And I agree, I think we need to have a more in-depth discussion on
Okay.
this particular item right now.
Very good. So we have a
We need
motion.
finance here.
Will you second to table it, and we'll just go ahead and table it?
Okay, yes, I will second. Thank you.
All right, all those in favor of tabling signify by saying aye.
Aye.
It is unanimous. We're going to table this, but we do have another consent agenda item, number 12, and consideration of possible action to approve a budget authority and expenditure limit increase the flood control district in the amount of $150,000 for the Natural Resource Conservation Service Award. Agreement number NR 23945700000C001, Amendment 1, to allow the Flood Control District to complete neighborhood mitigation efforts in the Copeland and Peaceful Way flood corridors for FY23. Do I have a motion to accept this consent agenda?
Madam Chair?
I think we already did.
Never mind.
We did vote on
I just wanted to read it twice because it was such a great number to read. Okay, sorry about that. Let's move on. Glad someone's paying attention. We need to resolve back as the Board of Supervisors. Do I have a motion?
I told him.
So moved.
All right, motion and second.
Second.
All those in favor of resolving back as the Board of Supervisors signify by saying aye.
Aye.
And we now have to resolve as the Jail District Board of Directors. We have one consent agenda item. Do I have a motion to resolve as the Jail District Board of Directors?
So moved.
A motion with a second by Supervisor Fowler. All those in favor, being the Jail District Board of Directors, signify by saying aye.
Aye.
It is unanimous. So we have one consent agenda item. And consideration of possible action to approve a second amendment to the independent contractor with Keith Commissionary Network LLC to provide comprehensive inmate commissary and bank services to the Coconino County Flagstaff Detention Facility in FY24 for the estimated revenue amount of $100,000. I think we've already entered into the contract. This is a second amendment to provide commissary and banking services. Members of the board, do you want to remove this from the consent agenda for discussion, or do I have a motion to accept the consent agenda item? Do we have a motion to accept the consent agenda?
I move that we accept this item.
All right, do we have a second by Supervisor
Second.
Vasquez? We do. All those in favor of accepting Jail District consent agenda signify by saying aye. Aye.
Aye.
Aye.
It is unanimous. We now must resolve back as the Board of Supervisors. Do I have a motion?
So moved.
Motion by Vice Chair, a second by Supervisor Fowler. All those in favor signify by saying aye. Aye.
Aye.
It is unanimous. We are now back as the Board of Supervisors and members of the board. We have a public hearing. This is a public hearing consideration of possible action to adopt ordinance 2023-07, approving a zoning ordinance text amendment to section 3.12.c.3e regarding medical marijuana dispensaries' hours of operation, changing the required closing time for medical marijuana dispensaries from 8 p.m. to 10 p.m. The applicant is Michael Perron of Tempe, Arizona. And I understand Community Development Director Jay Chrisselman is going to present on this item. So Jay, I'm turning this over to you.
Madam Chair, good evening. It's actually Jess McNeely is going to be presenting this item, his case.
Okay, if we have to hear from Jess. No, hi Jess. Thank you, Jess. Appreciate it. Please proceed, Jess.
Thank you, Madam Chair and board members. Good evening. This is Jess McNeely with Community Development Department staff. And I believe I'm sharing my screen. Are you all seeing my PowerPoint?
We do, Jess. It's perfect.
Good, good to hear.
You have it,
of
we still
course-
have it in PowerPoint mode, so you may want to turn it to slide mode.
How are we looking now?
There it is. It's perfect.
All right. Thank you, Madam Chair. As you stated, this case is a request. It's AM 22-007. It's a request to amend our county zoning ordinance with regard to medical marijuana dispensaries, and specifically their operating hours. Our applicant, as you identified, is Michael Perron of Tempe. He represents Green Farms. They are the only medical marijuana dispensary or establishment in our unincorporated county. And by the way, ARS, Arizona Revised Statute 11813C, gives an individual the right to request a zoning ordinance amendment, as Michael has done. This request specifically is a zoning ordinance text amendment to section 3.12C3E of our zoning ordinance. That would be to change the required closing time for medical marijuana dispensaries from 8 p.m. to 10 p.m. And this is a screenshot of straight out of our zoning ordinance. This section, section 3.12 of our zoning ordinance, and this was the request from the applicant. You see some of the other regulations that really come out of state statute that are in our zoning ordinance regarding other parameters around medical marijuana dispensaries. And the item here, of course, requesting that is requested for an amendment is sub item E, the operating hours of medical marijuana dispensaries from 8 a.m. to 8 p.m. currently, and is requested to be now extended to 10 p.m. I will point out that this is the only land use of all the land uses in our zoning ordinance where we have the hours regulated in this way. So when the board adopted regulations back in 2011 into the zoning ordinance regarding medical marijuana dispensaries, they got very detailed back then. And similar hours of operation regulations do not apply to other land uses under our zoning ordinance. But we typically let the state regulations regulate those types of details. When we look at the background affecting this request, in 2010, Prop 203 at the state level legalized medical marijuana in Arizona. And of course, this is for medical purposes only for those who qualify for the medical use. So following that, in 2011, the Board of Supervisors approved Ordinance 2011-03 to provide regulations for the operation of medical marijuana dispensaries. Actually, it included cultivation facilities as well. And that's what became section 3.12 of our zoning ordinance. Now, more recently in 2020, at the state level, Prop 207 legalized recreational, or commonly called adult use marijuana. So it is a separate use. And the county has not established regulations for recreational or adult use marijuana, but rather just relies on state regulations. So when it comes to the recreational or adult use, that is simply a retail operation as regulated by our zoning ordinance. So the state does heavily regulate this use. And there were only a limited number of licenses that were issued for medical marijuana dispensaries, along with Proposition 203. When Proposition 207 was then approved more recently, the established medical marijuana dispensaries were given priority for the recreational or adult use marijuana establishment licenses. Green Farms, which is the only medical marijuana dispensary in our county, in our unincorporated county, holds both a dispensary and a recreational adult use establishment license. However, this is a zoning ordinance text amendment. So even though this is the only use currently in our only establishment currently in our county that is being regulated by this detailed regulation, it would be a zoning ordinance amendment that would apply to any future dispensaries that would open in our county. It is important to note that there are no dispensaries in the state of Arizona north of the Green Farms location, and very few to the east. So this is a map that was provided by the applicant in this case. The pin drops here show where the establishments are licensed across the state, and you see the two right there at the Flagstaff location. The further north one is Green Farms, that is in the unincorporated county, and then there is one dual medical and marijuana establishment licensed facility within the city of Flagstaff. And you can see that that really there's nothing else further in northern Arizona, further north. So really the reason for the request, as submitted by the applicant, was increased travel times. With the earlier closing hours under the county regulations, county residents have often had to travel into the city of Flagstaff if they cannot make the more limited county hours. This can result in increased traffic and can result, therefore, in increased impact on county infrastructure and roads. And real reason for the request also is this would align our county regulations with the city of Flagstaff regulations, which also include which provide for a 10 p.m. closing time. And as the applicant pointed out, most establishments, the vast majority of the establishments in the state of Arizona also have 10 p.m. closing times. So this would get our county regulations certainly consistent with city of Flagstaff and the majority of Arizona. When we look at our comprehensive plan policies, and these on the screen are the policies that were looked at by the Planning and Zoning Commission at their public hearing on this request. We see a number of them here, and it is important to point out that the Planning and Zoning Commission did find that this request was consistent with these comprehensive plan policies. We have a sustainability and resiliency policy that applies, economic development policy, community services goal and policy, and a circulation, that would be like a traffic circulation policy as well, that would apply to this request. So when we look at the required findings of fact for a zoning ordinance amendment, that's requirements under our zoning ordinance to make a zoning ordinance amendment. Finding number one is that the change is consistent with the goals, objectives, and policies of the comprehensive plan and that ordinance, the zoning ordinance. The Planning and Zoning Commission's response and their recommendation to you all as the board is that this requested change is consistent with the comprehensive plan policies that support health and wellness of citizens and visitors, the local economy, and preservation of circulation infrastructure. When we look at finding number two, that's required, that the change will not be detrimental to the public health, safety, comfort, convenience, and welfare. The Planning and Zoning Commission recommended response was that the change would improve services to medical marijuana patients and reduce the need for them to travel longer distances. And when we look at finding of fact number three for a text amendment, that the change will not adversely affect the established character of the surrounding neighborhood, nor be detrimental to adjacent properties. The Planning and Zoning Commission's recommended response is that dispensaries are only allowed in commercial zoning, requires commercial zoning to have one of these medical marijuana dispensaries. where other similar businesses are allowed to stay open past 10 p.m. For instance, including stores that sell alcoholic beverages. So this would not detrimentally affect the character of these commercial areas. It's common in commercial zoning and commercial areas to have businesses that stay open past 8 p.m. certainly and until 10 p.m. So with that, Madam Chair and board members, following the Planning and Zoning Commission public hearing, where no public did speak on this item at that hearing, the Planning and Zoning Commission does forward a recommendation of approval for AM 22-007 to you all as the Board of Supervisors. And it is important to note that AM 22007 can be approved pursuant to ARS 11813C through approval of the ordinance in your packet. That would be ordinance 2023-07. And with that, Madam Chair, I would be happy to answer any questions.
Very good. And members of the board, you have heard from, before we open this up for a public hearing, do you have any questions of Jess? Jess, just to kind of sum up, it appears that you found that comprehensive plan compliance would be met by the recommended changes. And you cite the sustainability and resiliency 8, economic development 6, community services goal, community services 8, circulation 19. Is that correct?
Yes, Madam Chair.
And I also understand that this was out for public comment and there has been no objection or public comment on this. Is that correct?
That is correct.
All right, very good. Members of the board, any comments or questions that you might ask, or I will open this up to a public hearing. Okay, I'm going to open this up to a public hearing. Members of the board and members of the community, now is the time to be heard on this public hearing to adopt ordinance 2023-07. And as you heard from Jess, it's approving a zoning ordinance text amendment to section 3.112.c.3 regarding medical marijuana dispensary hours of operation, changing the required closing time for the medical dispensaries from 8 to 10, which is consistent to the recreational marijuana closing, as I understand it. Correct, Jess?
Yes, that is correct.
All right. I know that we have the applicant here. Michael, would you like to make a comment before I open this up to a public hearing? Or I can open it up and then you can make comments afterwards. I don't see, he is there. Is there anything you'd like to say before I open this up to a public hearing?
Thank you, Madam Chair. No, I'm okay.
Okay, very good. Then I'm going to continue to open this up to the public hearing and get your input, members of the community. And with that, I'm going to turn this over to Lindsay Daly, our clerk, to explain how you can join us at this public hearing. So Lindsay.
Thank you, Chair Horstman. And Jess, if you can stop screen sharing for a minute. If there's anyone that would like to make a comment during this public hearing, you can hit the raise hand icon that will appear if you hover towards the bottom of your screen. It looks like a hand. If you click on that, that will raise your hand and notify us that you would like to speak. If you've joined by telephone, you can hit *9, and that will raise your hand and notify us that you would like to speak. And we have no hands raised.
All right, members of the public, this is last call for you to be heard on this proposed zoning ordinance amendment, excuse me.
And there are no hands raised, Chair Horstman.
Very good. And then I'm going to close our public hearing. And at this time, Michael Perrone, who is the applicant, and Michael, if you have anything further you'd like to say, you did hear Jess's very complete review, but we'd love to hear from you as well.
Thank you, Madam Chair. No, I definitely agree with everything Jess presented. If you guys have any questions, I'm always happy to answer any questions, as well as moving forward, just to have like an open dialogue about it. Obviously, we are the only unincorporated dispensary or establishment in Coconino County. but just always trying to be just available for any questions, answers, and all, even past this point. So that was
Very good.
all.
Thank you, Mike. And thank you for joining us this evening. Members of the board, do I have any comments, or we have heard a complete review here? Do I have a findings, a fact that a board member would like to make, or a motion a board member would like to make? I will go ahead and just make some findings and then entertain a motion. I find, based on the information as presented from our staff, that the change in fact as recommended would be consistent with the goals, objectives, and policies of the comprehensive plan and also the ordinance. And now I find finding number 2 is also met, in that the change would not be detrimental to the public health, safety, comfort, convenience, and welfare. There's been no objection, and all requirements of the statute were in fact met. And so also finding 3, that the change would not adversely affect the established character of the surrounding neighborhoods, nor be detrimental to the adjacent property. This is merely a, if you will, a business change for times for the dispensary to be open, which would be consistent with the medical marijuana, recreational marijuana dispensaries as well. And so I do find that the requirements as required for a zone ordinance amendment have in fact been met. And I don't know if other board members make those findings as well, and if they would like to entertain a motion.
Madam Chair.
Yes, Supervisor Fowler.
Yes, I find the findings as read, and the presentation was covered a lot of the questions that we may have had. And so I find that it sounds reasonable to change the hours. So I move that we approve this particular item.
Thank you. We have a motion by Supervisor Fowler to allow the commercial zones dispensaries to be opened past 10 o'clock or to 10 o'clock, I believe, isn't that?
From 8 to 10
o'clock,
yes.
8 p.m. to 10 p.m. Do we have a second?
We have a second. Can I make my comments now or wait till we vote?
You feel free to make your comments now.
Okay, I just wanted to say that I concur with both of my colleagues, that I see the findings that it's not detrimental to the community to make this change. Sounds like it'll put our ordinance more in line with the state in terms of hours of availability. So I'm in agreement with this ordinance.
Thank you. We have a motion and a second, and a finding from my colleagues that the requirements for the zoning ordinance amendment have been met. All those in favor of the zoning ordinance amendment, please signify by saying aye.
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 It is unanimous. And so thank you, Mike, for joining us this evening, and motion's been passed.
Thank you, Madam Chair.
So we're moving on to our last item for today. And this is a discussion item, and this is a presentation from the Arizona Department of Environmental Quality staff to provide an update on per and polyfluoroalkyne substances, PFASs, proposed regulation, and the water testing underway and are completed in Coconino County. And I believe that Kim Musselman is with us. Is that correct, to introduce this item? If not, then I'm going to turn this over to Andy for you to introduce this item.
Thank you, Madam
She's
Chair.
here, Andy. Sorry, I was a
She's
little
here.
slow promoting her.
She was an
okay.
attendee. I see that Kim has her hand raised, so she is eager to present the item, and we are bringing her into the panelist area. So Kim, let us know. There you are.
And Kim, you just saved Andy from trying to say polyfluoroalkyne substances. So thank you for joining us. And I hope I said it right.
I don't know. We'll have Laura clarify the pronunciation when it's her turn. But thank you
Chair, Supervisors. I just wanted to take a couple minutes. We appreciate the partnership that Health and Human Services and the county in particular has with the Arizona Department of Equality and with ADEQ, and we are Environmental Quality, Arizona Department of Environmental Quality. And I just wanted to take a quick moment before I turn it over to Laura for her presentation to just clarify for the board and also the community members in terms of what HHS, Health and Human Services, at the county's role is when it comes to water and air health concerns, and that really to just explain that Arizona Department of Environmental Quality is the state agency that is their responsibility regarding testing and notifications around air and water quality concerns. And at HHS, our job is to make sure that we are providing the information that they give to us, to our community, and also provide them with other mitigation strategies in terms of protecting their health, especially for those who are immunocompromised. So I just wanted to make that opening statement and then to turn it over to Laura and Carusona. Hopefully I got it right or close to right. As she is here to share the presentation with the board, and then will also be available to answer any questions in discussion. I think there may be a couple of other folks on to support Laura as well. So that's all I have. And unless there's any other questions, I'd be happy to turn over the presentation to Laura.
Thank you, Kim, and thank you, Laura, for joining us. And I see we also have Matt with us, and so you may want to introduce those from ADEQ that are with us here tonight. And thank you for joining us, and we look forward to hearing from you.
Okay, well, thank you. Good evening, board members, Madam Chair. My name is Laura Carusona, and I am the Drinking Water Section Manager for ADEQ. Also with us today are Matt Narder and Lauren, I can't remember, Allison, sorry, Lauren. And today I'm going to show you a video about per and polyfluoral alkyl substances, also known as PFAS. It is a tongue twister, so you know, I guess eventually we'll all get to know this term really frequently. Recently, EPA has proposed a new rule to regulate certain compounds. There are over 29,000 compounds of this PFAS chemicals family. ADEQ has prepared this video, which I will show to provide more information on the compounds and what ADEQ is doing in advance of the proposed rule. And I will be around for questions after this. And let me go ahead and start. And please let me know if everything is showing correctly.
PFAS is a term for a group of chemicals that many Arizona residents are likely to hear more about in the coming years. We at ADEQ would like to provide you with a brief introduction of PFAS in Arizona so you can understand what PFAS are, what ADEQ is doing to address these chemicals in our environment, and what steps to take now to protect your health. First, it's important to understand some basic facts about PFAS. Per and polyfluoroalkyl substances, or PFAS, are a large family of man-made chemicals that have been in use since the 1940s. PFAS have unique physical and chemical properties that make them very useful for a wide range of applications, most notably stain and water resistance. But these same properties can make them highly stable and resistant to degradation in the environment, earning them the nickname forever chemicals. Because the length of their carbon-fluorine tail and the structure of their functional head can vary, thousands of unique PFAS molecules are possible. Some PFAS have been more commonly manufactured than others, including two of the most widely used and studied PFAS molecules, PFOA and PFOS. Scientific studies have shown that exposure to some PFAS may be linked to harmful health effects in humans and animals. Depending on how much PFAS someone is exposed to and for how long, certain PFAS can have potential harmful effects, for example, increasing the chance of getting some cancers, increasing cholesterol levels, and affecting reproductive health and child development. Because of their unique and beneficial properties, PFAS have been incorporated into many common consumer products, including carpets, furnishings, food packaging, cosmetics, clothing, cookware, and many others. In some cases, consumers can choose to limit their exposure to PFAS, for example, by avoiding products labeled as water or stain resistant, avoiding food in contact with grease-proof packaging, and avoiding personal care products with fluorinated ingredients on the label. Drinking PFAS-contaminated water is another potential source of exposure, but one that for many is not easily avoided through personal choice alone. However, in most cases, exposure to contaminated drinking water can be eliminated through testing, regulation, and treatment, something we'll discuss more in just a bit. The life cycle of PFAS starts when they are first manufactured by industry. Although Arizona has not historically been home to any PFAS manufacturers, these chemicals can make their way to our state through the purchase of consumer products, the use of firefighting foams, and as raw materials used in the production of other products. People may be exposed directly from using these products, but as they are used or thrown away, they also enter our landfills and our wastewater treatment plants, and in turn can be released into the environment where they can accumulate and do not easily break down. From there, they may end up in our food or our drinking water. With PFAS so common in the world today, it's not surprising that we find these chemicals in our bodies as well. The CDC has measured PFAS in the US population since 1999 and has found that PFAS are present in the blood of 99% of Americans. However, since 2002, the production and use of two of the most common PFAS, PFOA and PFOS, has declined, and researchers have seen a corresponding decline in blood levels. In the case of PFOS, by more than 85%. Therefore, despite their forever chemical nickname, we can see that reducing exposure to these chemicals can have a positive impact on the levels in our bodies. PFAS are not currently regulated at the national level or in Arizona. The U.S. Environmental Protection Agency first released provisional PFAS health advisories in 2009, which defined advisory levels for PFOA and PFOS. Since that time, the advisory levels have been revised lower, first in 2016 and again in 2022, and were expanded to include additional compounds, PFBS and Gen X chemicals. Health advisories are not legally enforceable. They identify the concentration of a contaminant in drinking water at which adverse health effects are not anticipated to occur over a lifetime. In March 2023, EPA took the next step. After many years of study and recent research, EPA proposed a national primary drinking water regulation. The proposed regulation would create a maximum contaminant level, or MCL, for 6 common PFAS. An MCL is the maximum concentration of a contaminant allowed in drinking water that can be delivered by a public water system. EPA has proposed to regulate PFOA and PFOS at a level of 4 parts per trillion, while 4 other PFAS are proposed to be regulated as a mixture using a standard calculation called a hazard index. These proposed MCLs were developed by EPA to account for chronic exposures to low levels of PFAS over time. At concentrations typically found in drinking water, they are not dangerous in the same way as acute water contaminants like E. coli, which may be dangerous if consumed even once. It may be helpful to understand the unit of measure that's being used by EPA for the proposed regulation. 1 part per trillion is equivalent to a single drop of water in 20 Olympic-sized swimming pools. So this hopefully gives you an idea of just how small these numbers really are, and also how cautious EPA is being about the long-term risks associated with exposure to PFAS in our drinking water. ADEQ is closely following PFAS developments at the federal level, and the EPA has developed a roadmap that lays out their commitment to take specific actions. It's expected that EPA will finalize the proposed drinking water regulation within the next year. However, implementation of the final rule will occur 3 years later, giving states and water providers the time needed to address contamination. In addition to drinking water regulations, EPA has proposed designating certain PFAS as hazardous substances, which would allow the state and federal government to hold polluters accountable. And EPA has also proposed aquatic life standards to help protect wildlife in our streams and rivers. These are all just a few of the many federal PFAS developments that are expected over the next several years. So what is ADEQ doing about PFAS in Arizona? ADEQ is taking several steps to protect public health and help our state prepare for future EPA actions. Beginning in 2018, ADEQ conducted targeted screening efforts to understand the scope of PFAS impacts in Arizona. This testing included drinking water, groundwater, wastewater, and biosolids. In 2023, we began a comprehensive PFAS testing program to make sure that all of Arizona's regulated drinking water systems are sampled for PFAS in advance of federal regulations. If PFAS are detected, we can begin working right away with affected water providers to collect more data, find solutions, and identify funding to reduce exposure to PFAS. We'll have more details on this important program in just a moment. While we're actively working to protect drinking water, we're also trying to identify the most effective ways to prevent more PFAS from entering our environment. ADEQ recently piloted a program to help Arizona fire departments stop their use of PFAS-containing aqueous film-forming foams known as AFFF. The program was allocated $395,000 during fiscal year 2023, which has allowed us to work with 40 fire departments throughout the state to replace and properly dispose of almost 6,000 gallons of AFFF to date.
We had 275 gallons that we no longer were utilizing because of the risk. And a truck easily pulled up, loaded it, and unloaded that F500 that we'll now be able to distribute to our trucks.
Being involved in this program was so essential and critical for us to get rid of these chemicals.
As someone who's been in the fire service for over 20 years and have watched friends be diagnosed with cancer, knowing that there's people out there that care enough to replace these foams and anything that we're determining as a cancer-causing agent, that being on top of mind for them, it just means a lot.
As mentioned earlier, ADEQ is currently engaged in a comprehensive statewide effort to ensure that all regulated water systems are tested for PFAS. EPA is currently requiring that systems serving 3,300 customers or more sample their drinking water for PFAS. However, in the state of Arizona, the majority of systems serve fewer than 3,300 people and will not be sampled under the EPA program. Therefore, ADEQ has committed to using $3 million of Federal Safe Drinking Water Act funds to sample these small water systems and help ensure that all regulated water systems in Arizona will be tested. Results are generally provided to water systems within 2 to 4 weeks of sampling and are posted to the ADEQ website. If PFAS are detected, ADEQ provides the system with a PFAS toolkit, specially developed to help water systems meet the challenges this may cause. The toolkit includes information on funding, customer communication, and potential next steps. Systems are asked to follow EPA recommendations to inform their customers of the results. Our program to test small drinking water systems has a number of benefits for the systems and their customers. First, it provides PFAS sampling to systems at no charge, potentially saving them thousands of dollars. These systems can then be notified of PFAS detections much earlier than if they wait until they are required to sample under forthcoming federal regulations. For those systems with PFAS concentrations higher than the EPA's proposed limits, they can get a head start planning for expanded testing, evaluating potential solutions, and applying for federal funding if necessary. With many systems across the nation facing similar challenges, it's important that Arizona's drinking water providers begin planning to meet the new rules as soon as possible. So what can you do if PFAS is detected in your drinking water? If your water is confirmed to contain PFAS, in many cases, action is not necessary immediately. You can choose to reduce your exposure as soon as possible by not using untreated water for activities like drinking, cooking, washing produce, brushing teeth, or preparing formula. However, it's generally safe to continue using untreated water for activities like washing dishes, showering, laundry, swimming, and watering your yard. If you have concerns about PFAS in your water, there are a number of at-home treatments available, such as activated carbon and reverse osmosis. You can check sources such as the NSF or your local filter installer for more information on effective treatment systems for your home. It should be noted that boiling water will not remove PFAS, and bottled water providers are not required to test for PFAS, so use caution if you choose to drink bottled water. PFAS can be a complicated topic, and this presentation is meant only as a brief introduction. If you'd like to learn more about PFAS in Arizona, please visit our My Community webpage. There you can find a map displaying the results of statewide PFAS screening and links to other helpful resources. If you'd like to talk with someone directly, we have staff available to speak with you and answer any questions you might have. Thank you for listening.
Thank you, Laura, for the video and for the information. And I guess from surprisingly to hear that if you drink bottled water, they do not have to currently test for this. Is that correct?
They do not follow the same EPA standards that drinking water systems do. They are regulated by oh gosh, I know this answer. I'm blanking out, sorry. By the Food and Health Administration.
Mm-hmm. Thank you for that. So that's surprising.
Mm-hmm.
All right. Any other comments, questions, members of the board? Laura, anything else you'd like to present to us?
A couple things. Oh, I'm sorry, Supervisor Fowler, please go ahead.
So you're testing water approved, what is it, the approved water system?
We are testing public water systems at their entry point to the distribution system. So that's the point where if there's any treatment such as chlorination, that it goes into the distribution system prior to the first customer.
What about in the communities that use natural springs?
If they are a public water system, we are regulating them if springs are their source water. If they are not a regulated public water system, we are not testing them. ADEQ does not have authority over private wells or small private springs.
Okay, thank you. This is a pretty scary presentation.
Yes, it is. So anything further, Laura, you'd like to present to us?
No, but I did want to talk about the testing that we have conducted in Coconino County already. Out of the 31 water systems that we have that are in our scope for testing, we've tested about 15 of them. So far, the samples are still being analyzed at the lab, so we have not received any results back. And if you guys are interested in updates later on, we would be more than happy to come back and present to you what the results would be, or what the results are.
I think we would like to hear back from you what the results are.
Okay.
Now that you've scared us, we'd like to hear the results. So.
Well, this wasn't meant to scare. We really did want to inform.
It is a good information. It's good to be aware, but it's like, it kind of feels like there's really not much we can do, just to rely on you. And I'm glad you're working with. And so the testing, are you working with the fire departments in Coconino County also, and others that use that chemical?
Yes, we have gone out to the one fire district in Coconino County and collected some fire foam. Let me get that information. I'm sorry, didn't pull that up ahead of time. Matt, if you're on, could you let me know who that was that we tested? I'm sorry, that we got the fire foam from?
Yeah, Laura, it was the Pinewood Fire District.
Thank you.
Pipes?
Right now, we are not, because this is strictly for what ADEQ has jurisdiction over. Navajo Nation in your part of the world has jurisdiction over the water systems on tribal lands.
Well, Laura, we look forward to you giving us the results of the testing and really appreciate this information. And we'll see you back, I'm sure. So any other comments or questions, members of the board? Lauren Allison, I'm sorry. Lauren, hi.
Hi, so my name is Lauren Allison. I am the community liaison at ADEQ and I cover Coconino County. And I just wanted to say thank you really quickly to Kim and Eve in Health and Human Services, as well as Lindsay for allowing us to present about PFAS and the work that we're to be doing soon in Coconino County. So I just wanted to acknowledge Kim and say thank you for partnering with us and sharing that same objective of protecting public health.
Thank you, Lauren, very much. And thank you for joining us as well. So.
Madam Chair.
Yes, Supervisor Fowler.
The presenters, if we can, if you have any community education, maybe workshops that are coming up, if you do webinars or if you have materials, if you could just email them to us and be able to get it out to our communities. Thank you.
Thank you.
We absolutely will. Thank you.
Great idea, Supervisor Fowler. All right, seeing nothing and anything further. Kim, thank you for bringing the information and for bringing the ADEQ team with us this evening. Really appreciate it. And thank you all for your time. And with that, we're going to let you go. And with that, members of the board, we've hit the end of our agenda. So unless there's other comments that need to be made, I think we can say it's been a long enough day. And I wish everybody a good night and sleep well. And I'm sure we'll be seeing you all soon. So thank you so much. Appreciate everybody's time today.
Thank you.
Bye.
Thank you. Good night.